In the United States, broadcast media are extensively regulated by the Federal Communications Commission, which operates under broad authority first conferred by Congress in the Communications Act of 1934. Before proceeding in more detail into broadcast regulations, it is important to remember what broadcasting means for legal purposes. Broadcasting, in law, means only traditional over-the-air terrestrial radio and television stations. Cable and satellite delivery of radio and television programs is subject only to minimal government regulation, and its content receives full First Amendment protection. Radio and television programs streamed as online videos also receive full First Amendment protection under the Supreme Court's ruling in ACLU v. Reno. We also should remember why the content of broadcast radio and television programs can be regulated in ways that would never be allowed for books or newspapers. The Supreme Court articulated these reasons in the 1920s after broadcasters' experiment in self-regulation largely failed. Radio and television broadcasters use a resource owned by the public, the electromagnetic spectrum of broadcast frequencies that carries their programs. Because the public owns this resource, the public can impose conditions on broadcasters who want to use these frequencies. Additionally, because only a limited number of stations can broadcast cleanly in a particular market, some kinds of rules are needed to determine who is allowed to transmit on each frequency. The government establishes these rules using its authority as the trustee that administers the electromagnetic spectrum on behalf of its owner, the American public. In more recent decades, the Supreme Court has recognized further justifications for government regulation of broadcast content. Broadcast radio and television are considered pervasive and intrusive media that force their content onto the eyes and ears of audiences thought to be at the mercy of whatever broadcasters choose to transmit. Such media also are said to have special power on the minds of children. Finally, some scholars have argued that the government should ensure equal access to the means of broadcasting regardless of financial resources, though the courts have not accepted this justification. The guiding principle behind government broadcast regulation is that radio and television stations must operate in the public interest, convenience, and necessity, providing a public service in exchange for monopoly privileges over their broadcast frequencies. In general, even content-based restrictions on broadcast speech are evaluated under intermediate scrutiny, not the strict scrutiny the courts use when content-based speech restrictions are applied to spoken, printed, or online speech. One important area of government regulation determines who may hold a broadcast license. Largely because of the fear of foreign nations spreading propaganda over the U.S. airwaves, an applicant for a broadcast license must be a U.S. citizen. If the applicant is a corporation, at least 80% of that company's ownership must be individuals or companies in the United States. This rule is the principal reason Rupert Murdoch, a native of Australia, has obtained U.S. citizenship. An applicant also must show his or her good character. This usually means that an applicant cannot have been convicted of a felony, and that there is no evidence the applicant is dishonest and likely to lie to the FCC about the license application or any other matters. Lying to the FCC to obtain or keep a broadcast license is almost always considered a violation of the good character requirement, and such dishonesty is the most common reason for the Commission to deny a license application. Applicants also must show that they have the technical know-how to operate modern broadcasting equipment, or that they will hire staff with that knowledge. A station also must be adequately financed. The public interest is not served by giving a broadcast frequency to someone who cannot afford to fill the airwaves with programming. A license applicant must show the ability to keep the station operating and supplying programming for 90 days without advertising revenue. Finally, the FCC also limits the total number of radio and TV stations one license holder may own in a particular market, to preserve some diversity of the information, opinions, and cultural programming available in one place. These rules were eased considerably under the Telecommunications Act of 1996, a law often described as deregulating broadcast ownership and often criticized as allowing one owner to control too many media outlets. A station's broadcast license can be revoked for failing to comply with the FCC's regulations, though this penalty is rarely used. More typically, the FCC uses the threat of revocation to encourage a station to comply with the law. Often a simple warning letter from the Commission is enough. The Commission also can impose a fine called a forfeiture against a broadcaster, and it can specify changes that must be made as a condition of the broadcaster's license being renewed at the broadcaster's regular review every 8 years. In addition to determining who can hold a broadcast license, the FCC also attempts to promote the public interest, convenience, and necessity by regulating particular kinds of broadcast content. At the top of the list is political advocacy. Lawmakers and regulators do not want one faction in political debates to have a dangerous advantage by controlling most broadcast time. Even after the demise of the Fairness Doctrine, political advertising and editorials remain heavily regulated, and stations are required to sell advertising time to major political candidates, even though the Supreme Court has prohibited applying such rules to print or online media. Although commercial stations currently have a right to air editorials on public issues and in support of candidates, debate continues about whether such editorials should be limited or subjected to the right of reply rules that were in place in previous decades. The requirement that broadcasters serve the public interest by airing educational programming, especially for children, is a subject of extensive debate. Over every 6-month period, a broadcaster must average 3 hours per week of such so-called core programming, and the amount and content of advertising during such programs is limited. However, what constitutes core education programming is not always easy to determine. Additionally, profound arguments have been made on both sides about whether the public's preferred types of programs or the FCC's judgment about what is in the public interest should be the determining factor in what broadcasters air. Broadcasting information concerning lotteries is generally prohibited, and broadcaster-sponsored contests are heavily regulated. Information about a state's lottery may be broadcast by stations in a state that has a state-run lottery, and a station also may air information about lotteries such as raffles and giveaways by nonprofit organizations whose principal purpose is not gambling. Information about contests is permitted only if a broadcaster provides all material information a potential contestant would want to know. A station also cannot provide special assistance to one contestant without disclosing that fact to the audience. Broadcasters are prohibited from airing hoaxes, as well as any other content that might incite imminent lawlessness or a danger to the public. Strictly speaking, these regulations include false or distorted news broadcasts, though the FCC rarely enforces these rules against journalism for fear of exceeding its authority and violating the First Amendment. Finally, broadcasters are prohibited from airing obscene or indecent content. The only exception is that indecent material can be aired during the safe harbor period from 10 p.m. to 6 a.m. Obscene content is prohibited at all times. As advances in technology continue challenging the assumptions underlying broadcast regulation, a number of new questions confront Congress as it determines how much authority the FCC should have. Arguments for expanding, diminishing, and eliminating the FCC have been proposed. Additionally, policymakers also must decide how much of the broadcast spectrum to make available for commercial broadcasters and how much should be withheld for the government's own use. As digital and satellite communication becomes increasingly common, the government needs fewer over-the-air frequencies than it once did. Finally, much debate surrounds the First Amendment status of broadcast media. Why, for example, should the same program receive 3 different levels of First Amendment protection, depending on whether it is transmitted over the air, conveyed by cable or satellite, or streamed across the web? A number of scholars and policymakers argue that technology-based distinctions among media are producing an incoherent body of law that does not reflect the realities of today's media landscape.